Welcome to Sir Lancelot's Real Estate Roundtable, your guide to mastering the realm of real estate in Central East Florida. I am Sir Lancelot Lenard, ready to uncover the secrets of seller strategies, home staging, mortgage mastery, and more. From Daytona Beach to Cocoa Beach, Lake County to St. Augustine, join me as we navigate the intricacies of real estate. As the leader of the Sir Lancelot Group at Florida Homes Realty and Mortgage, I'm here to arm you with knowledge and innovation, whether you're a seasoned homeowner or a first-time buyer, unveiling the kingdom of real estate, one roundtable at a time. Real estate deals don't end at the closing table. They echo for generations. Too often, families find out too late that a missing conversation, a hidden debt, or a poorly structured estate plan can turn love into lawsuits. On today's episode of the Real Estate Roundtable, we're joined by a powerhouse guest who's on a mission to change that. Lauren Alexis Klein, Esquire, is the co-founder and CEO of Flourish Law Group, a boutique estate planning and elder law firm serving families across Fort Lauderdale and St. Petersburg with over 11 years of experience crafting wills, trusts, and probate strategies. Lauren helps everyone from the middle class to the ultra wealthy protect their legacies and secure their futures. If you've ever wondered how property inheritance and family dynamics collide in ways that can either build wealth or break bonds, you do not want to miss this conversation. Lauren, welcome to the podcast.
Wow, Lancelot, that was an incredible introduction. Thank you. Thank you for having me on. I'm excited to be here.
So, Lauren, every superhero has an origin story. What inspired you to step into estate and elder law and ultimately co-found Flourish Law Group?
Yeah, so I was actually going down the track to be in the financial space. So if you recall back in 2008, 2009, when the world was going crazy, it's gone crazy multiple times since then, but I think back to that time period. I was a college student. I was interning at one of the big brokerage houses here in town, national brokerage house, and I was watching the world burn, at least from a financial perspective. And so I did what so many others do. I said, hey, maybe I'll go to law school instead. Bide my time and see if it was a good fit for me. I always thought maybe I would go to law school at some point. And I started taking classes, figuring out what I wanted to do. That's when foreclosures were really the kind of the big thing. And I knew that's not what I wanted to do. And then I stumbled upon a wills and trust class, which full circle, I now am a professor of wills and trust at my law school. So very cool to now be in that role. And I loved it. I found it very interesting. It just triggered something in my brain where I was like, wow, this is very similar to what I was going to be doing as a financial advisor, a stockbroker, but just from a different perspective, helping families get their legacy in place, get their estate plan in place, guide them through the process, talking about money and taxes and all of those things. And then I ended up taking a tax class. And it further solidified, wow, this is really what I love. This is how my brain works. And so I finished law school. I got a master's in taxation, an LL.M in taxation. So I went to school an extra year and moved into private practice. I started at Deloitte, so one of the big public accounting firms out there, big four public accounting firms, and realized I really didn't want to work with CFOs and their teams. I wanted to work with families. So that's what led me into trust and estates and related tax planning. I was at a big law firm for many years until I realized, hey, I could probably do this better myself in a more effective and warmer way. And just about 3 years ago, I co-founded Flourish Law Group with my best friend.
Oh, that's awesome. Great story for that. And it's just such a good goal to look out for others, I think. And the more people we can help, the more our businesses flourish in that matter.
Yeah.
So
Yeah.
was there a pivotal client story early on in your career that showed you just how much the right planning or lack of it can impact a family's future?
I have had so many stories over the years. I'm trying to think if I can think of one specific one. What I'll say is, while I try to think of a good one, is I have seen time and time again just normal families who just they don't understand what an estate plan is, what the purpose of it is, why it's so important. And then mom or dad passes away, or maybe the second parent passes away, and the family has to go through what's called the probate process, which essentially means if someone has not probate proofed their estate, either by having a revocable or irrevocable trust in place, moving assets into that trust, or naming beneficiaries on bank accounts, brokerage accounts, life insurance. There's also planning that can be done with real estate. If I just own something in my individual name and I pass away, even if I have a will, it still has to go through the probate process to get to the right beneficiaries if that planning is not done. And so I see just countless examples of families spending thousands and thousands of dollars on legal fees, waiting sometimes years to get access to assets, which is crazy if you think about it. Having to go through that process when you're already grieving a family member is awful. It's just awful. So rather than one crazy story, and I'll get to a crazy story in a moment, I think what's more impactful is just the everyday family not planning, not knowing, because we don't talk about this topic around the dinner table very often. I'm trying to change that. But because we don't talk about these things, it impacts our family, can lead to litigation, like you said in your introduction, if there isn't clarity or if there's family tension that wasn't resolved before the parent or the person passed away, it can become really disastrous at a time that people just need to grieve. So I think just that ongoing watching families struggle and suffer has really been impactful to me as an attorney and a human.
Yep, definitely. These probates, I've as a real estate agent, I've seen a few of them, and they're not cheap. 8 grand, easy on a low
Easily.
end, cheap property. And we're looking at, okay, we're inherited a $250,000 property, and we have to come up with $8,000. And we're talking about people that work 9 to 5 regular jobs who are making $40,000 a year. Coming out of pocket $8,000 is not a small feat for these. And how much does it cost to do a trust? Really, it's not as much. And you do that trust and you protect your family from going through those probates. And then you get to decide who's in control too. It's not like a bunch of siblings bickering over what to control, who to control, how to do it properly. It's, hey, she's in control because I trust her the most about making sure that this will be done right. And she's the fairest of them all, let's say. So she'll divide it up properly. I
Yeah.
gave her the instructions of how to do it. No, and that's in a trust. And I've been learning a lot about trust since I started this podcast because I had multiple attorneys on that do trusts, but they're different. Everybody does different things in a different way. Some help investors, some
Sure.
help like yourself helping families. So they're all different and they all do it for a different reason. And it's so interesting that we can get to these conversations and we can share it with people and get it out there. Because I think every person that is living at the moment and has somewhat of a wealth built up, even if it's one single family home, that should be passed down through different channels than it is a lot of instances.
Yeah, because what's happening is essentially at each generation, if there isn't an effective estate plan in place, you're losing money, you're losing time, you're potentially being tax inefficient. So you're not creating generational wealth at each generation, you're actually potentially lessening the wealth. And that's what so many wealthy families have understood so well for so many years. And I used to work exclusively with the top 1% of the top 1%. But I saw what we were doing for those clients, and I realized those same strategies are effective for what I call like my own family, a normal family, high earning, building up our wealth. But I didn't come from wealth. I wasn't handed a big trust. I'm building that for my family and for my kids. And it's been for myself really fun to see how you can apply those strategies to normal folks as well.
Correct. And what are the biggest shocks families face is hidden debts and or financial burdens left behind? What are some examples you've seen where poor planning created massive surprises?
So I've seen so many examples. Sometimes there's been accidental disinheritances of family members because there's DIY documents. Sometimes the estate planning attorney that helped draft the documents just made it very cookie cutter and they didn't actually ask the family what was going to happen, if there was a family dynamic, litigation. Sometimes there's a big family business or a big real estate portfolio that is inherited. And let's say there's no estate plan or a very, very bare bones estate plan. So now you have all of these family members owning a business together who, one, may have no idea how to run that business. So they're going to run it into the ground. Two, they might hate each other's guts, or now that mom or the matriarch or the patriarch is gone, all the family drama that everyone was keeping under wraps for the sake of mom or dad, the bets are off. So now they're all at each other's throats. This business or real estate portfolio that the family has built up, and that was like the legacy of the family, now goes down the tubes because no one knows how to run it. They're suing each other. The amount of money that people are willing or need to spend in litigation, especially probate and trust litigation, can be absolutely astronomical and just, again, eats away at that legacy. So I think at the end of the day, it's how can we protect our legacy? How can we ensure that the most money possible is transferring to that next generation? And I think this is the most important time in at least as long as I've been on this planet, to talk about it, because we are in the midst of the great wealth transfer. There's trillions of dollars that are going to be passed down. It's already begun, passed down from baby boomers to Gen X, millennials, Gen Z, so on and so forth. So we have a massive opportunity right now to all become more financially healthy and make sure that we're not losing out on inheritances and assets that are being passed down.
For sure. There's so many instances, as you said, and people that don't know how to deal with it. And this is not coming from nowhere. Like, financial education is a must, basically, to run a portfolio. And there might be only one or two children. Let's say you have two, three children or four children, they have their children. You pass away, you're the guy who holds everything in a hand. You have the trust, you put everybody in the trust, but you didn't name the actual person that's going to run the trust, the next trustee, basically. Hey, I'm passing the matriarch mantle to you now, that I trust you could run this business because you've been next to me. Let's say there's one child that grows up with you and always attached to you. And like I did with my father. So I was always with my dad all the time. My two other brothers, they weren't not that interested in what the dad's business was. So at the end of the day, I was the one after he passed. My mom inherited the business, but she didn't know what to do because she was not running the business, that part of the business. She had some good advice because, of course, she was next to my dad all her life, but I was the one out there doing the work because I was the one next to my dad. Now, we didn't have bickering or fighting after my dad died because he figured everything out for us. But if we didn't have that, and my two brothers would have said, hey, I want a piece of this, I want to get a salary from this and that, and I want to say, it would have been a totally different ball game of how to run that business. Because now we're like, hey, there's three heads in one pot. And you're like, trying to figure it out. One is business savvy, one is humanitarian, the third one's a little different. They all want to do different directions. And you're like, okay, that's not how we run a business. You get what I'm
Right.
saying?
Oh,
So,
oh, I see it. I see it all the time, all the
yeah,
time. And you're lucky that your family, one, that your dad had figured that out, and two, that everyone got along, because I have seen the exact opposite of that happen way too many times. And
oh,
it tears families apart.
we had a sibling come out of the woodworks that I've never met in my life,
Oh, wow.
putting their hands up and like, where did you come from? I have a signed document that your dad is my dad too. So I want a part of it. You're 40 years old. I was like 22. I was like, I've never met you in my life, never
Wow.
seen you.
Wow.
But you never know. This was back in the day. He was in a new country. He was basically signing whatever they shoved under his nose at that point. He was like 18 years old or something like that. And hey, sign this. And he signed it. He had his name signed to it. We asked her to do a DNA test. She was not willing to. But
Mm,
this is where a trust comes in. But because my dad set up a trust and a will, she didn't get the part from the certain parts of the business and real estate because she was not in the will or the trust.
right. Because if you don't have a will and
Yeah.
a trust, then the basically you're called dying intestate. And the state of Florida, or whatever state you reside in or country you reside in, dictates who receives the assets. And if there is an unknown heir, which does happen, I actually just taught that last night in class. So it's funny timing that you brought that up. But then if they can prove that they are a legitimate heir, then they're an heir at law of that estate, and they would be entitled to potentially a piece of that pie.
An equal
Yeah.
share, if I'm not
Yeah.
mistaken.
Right. And if
So,
there's no will or trust, that dictates how they receive it outright too. So
yeah.
now they own outright a piece of the family business. Is there an operating agreement? Is there a shareholder agreement that says what happens to that family business? Are they going to try to sell? Are they going to try to force a sale? Are they going to try to run it into the ground? You don't know. You really have no idea.
Yeah, exactly. It would be cool if somebody that would have the knowledge and the wealth would come out of the woodwork, but that's never the case. It's always someone from a trailer park that ends up in the, hey, I want my share because I want to buy more beer. Oh my God, not the family here. It's never the rich uncle from a different country that comes out of the woodwork and starts helping the family business grow even larger.
Right.
It's
Right. It
always
leaves you an
that
inheritance of $1 million.
exactly doesn't need the money. It just comes to help. It's always the dude that just gonna blow through everything. It's just sorry, but that's the truth. It's always that person
Yeah,
because maybe the rich guy's not gonna hold his hand up because I don't care. So
exactly.
how do you help families safeguard against these landmines before they even ever become an issue?
Like you said, having a will and often a trust in place is one of the best ways to do that. But that's just the beginning because there are many trust and estate attorneys out there. And a lot of them will just give you something cookie cutter. They won't ask questions. They won't really hear something and say, let's talk about that further. So, having a good estate plan that matches your facts and circumstances, matches your family dynamic, matches the assets and aligns with the assets that you have is absolutely imperative. So it's so great to hear that your family had done that because you can see how it transfers the wealth in so much of a more efficient way, keeps the family together and happier. So, what I always tell everyone is talk with a qualified estate planning attorney about the assets that you have, the family that you have, and then figure out what the best plan is for you. A lot of times it's not a trust. Some clients don't need a trust, especially if all of their children are older. Maybe there's limited assets. Maybe let's just say they have a condo, a brokerage account, and a bank account, and they have one adult daughter. They might come in and say, hey, I need a trust. And the reality is they may not. Maybe they just need to do beneficiary designation. So transfer on death or payable on death on the bank account and the brokerage account. Maybe for their home, if they live here in Florida, they can do what's known as an enhanced life estate deed or a ladybird deed, which essentially is a beneficiary designation for real estate. We don't have that in every state in the US, but in Florida, we're lucky enough to have that. And that automatically transfers that asset to the recipient beneficiary at the owner's passing. And it's revocable. So the person can do this ladybird deed if they sell or they want to modify, their daughter pisses them off, they can change it. But oftentimes, which is nice, but
Yeah.
oftentimes it is a trust, especially if there's minor children, if there's wealth that you're building or you already have built up. You want to have the trust in place because it can provide for it's like a backpack that you put all of your assets in. It's a private document. A lot of people don't realize if you go through a probate, all of that information becomes public information that someone can look up on the court docket, which personally, that scares me. I don't want anyone knowing my beneficiaries and what I have, especially with the amount of scam artists out and fraud in the world today. So a trust is a private document that allows you to pass assets in a way that you want to do so in an efficient way, pass your businesses to your family members, your loved ones, whoever it might be. But one really important part that often gets missed, but is probably the most important part, is you actually have to title the assets into that trust or name the trust as a beneficiary. Because let's say I have a bank account that I name my spouse as the beneficiary. Even if I have a trust, that will override the trust document. So you want to
Ah,
make sure that
everything.
everything that yeah, and that the attorney is looking at everything with you and making recommendations because we see it all. We actually just had a client all the time. People are moving down here from the Northeast. A couple came to us. I think they were worth like 16 million. They had an estate plan for New Jersey. The estate plan itself was good. I was like, yeah, this looks good. We're going to update it for Florida to make sure that you're becoming a Florida income tax resident to get away from New Jersey's income tax
Yeah.
at the state level. So we're going to update your documents. But then when we started looking at all of their assets, they had IRAs, brokerage accounts, bank accounts that were never moved into the trust, or the trust was never named as a beneficiary. So they would have had a very expensive probate if they had passed away with no further planning done. And they're like, hey, I went to this great attorney. I don't know what happened. So I always say, make sure whoever you work with as your trust and estates attorney is going to help you fund your trust because it is one of the most important pieces, if not the most important piece of an estate plan.
And I think trust, you can make just stipulations in the trust too. Even if you pass, you can still control what's happening in your family. As
Mhm.
into, I know that because I talk to so many trust attorneys now, that you could put stipulations in that if my daughter becomes 21 wants or 18 and wants to go to college, you can nominate what you can allocate assets to towards. Oh, I want to go
Yeah.
study arts. And they're like, nope, that doesn't work here. You should pay for that on your own. If you want to study engineering or law or be a doctor, the trust will pay for it. Like you could
Yeah.
still guide them
Oh,
in a
yeah.
way to your dad. It is so
Yeah,
cool.
as long as it's not contrary to public policy, we tell our clients you can really do whatever you want in that document. Now, there's some exceptions. You can't entirely disinherit a spouse without a prenup or postnup, and there's some rules with Florida homestead if you have a spouse and minor children. But other than those things, you can really do whatever you want. We've had clients do so many cool things over the years. One thing that we've done a lot lately with clients is they say my child can get an annual distribution that equals their salary. So if they go out and they earn 100 grand that year, they show the trustee their 1040. The trustee the following year can make a distribution of 100 grand. Now we might have exceptions for like education, maybe, or health care. If they have an emergency, that we can make exceptions, but that's to make sure that children don't become trust fund babies. They stay motivated. Even in families that are not like the Rockefellers, you can still have children that if they know they're getting a $1 million life insurance policy, maybe their motivation goes from a 10 to a 7. But if they know that they have to actually put in the work before they get a distribution, yeah, you might be able to get some more motivation. Or maybe you'll give them money to start a business. Maybe you'll give them money to have a wedding. Maybe you'll make an exception if they're a stay at home mom or dad to make sure that you're still supporting them. There's so many amazing things that you can do within the document. You can name, like you said, who the trustee is, especially if the children are younger. Maybe you want a corporate trustee or a third party family member that you can trust to make sure that they're not
Especially if
just
they're
pulling
minors.
out all of the money. Oh,
Oh,
especially if 100%. They couldn't
yeah.
be a trustee. And you definitely don't want a 15-year-old or a 4-year-old just having free reign. Or, God forbid, if you have no will or no trust or it's ineffective, an 18-year-old who gets everything on the day they turn 18. If I received a couple $1 million at the age of 18, I don't
I
know what
don't
I would have
I don't
done.
think I would be alive. To be
Right?
honest, I
Like,
would have went. I lived in Europe, the mecca of all places. I probably would have ended up on Ibiza or something, hanging out, or Saint Tropez. Because back then, when I was 18, it was big. Welcome to Saint Tropez was one of the songs that was
yeah.
playing.
Yeah. Oh,
I would have
yeah.
been one of those guys in French Riviera sipping champagne.
100%.
Go to, yeah, you're 18. What else are you gonna do? You just became a millionaire. But yes, definitely. I like the things that you could do with it and the mechanisms you could put into place. I think about it every time, like what I would put in there. Definitely the wedding I would put in there. And even if you're still alive, it could take effect. Correct. So, hey, I am 70 or whatever years old. My daughter is getting married. I put these stipulations in place in the trust, so it still could kick in, even if you're not there. Like she's getting married, so she would get $100,000 for the marriage or whatever. Or she's 18, she's getting a car. Boom, from the trust payout for the car. Or the trust will purchase a car in her name, or the trust will purchase a car in the trust name, and then she would be the designated user for the car. Because that's how you keep
Yeah.
wealth. No, like you could still do that.
It
No,
depends. It depends. So if it's a revocable trust, which is like the foundational trust, then when you're alive, you are typically the primary beneficiary. Now, you could have your spouse and your children as beneficiaries, for sure. That is absolutely possible. But usually, the provisions of, okay, the trustee is going to pay for a wedding or this amount will go out per year, those typically kick in after your lifetime because when you're alive, you can just control whatever happens. You have full reign,
you
usually
still
as your
sign
own
off on it
trustee.
or deny.
Exactly,
Yeah.
exactly. So usually those trusts for the children are created either at your death or your spouse's death, depending on the what you want to do with your wealth. But there are what's known as irrevocable trusts that you can create during life for a spouse or for children or for a child. And that's usually once you get to a certain wealth level or if you have asset protection concerns, because then you're making a gift into that irrevocable trust out of your name into this trust. And then it could say $100,000 every year to my children or purchase a car or whatever it might be. But it has to be a specific back pattern for that to make sense. Right now in the US, if someone's a US citizen or permanent resident, they can give away or die with almost $14 million. before they have to worry about a federal estate tax. So if you're a married couple, either way, it's a very high dollar amount. That's when our clients start to move assets into irrevocable trusts, make gifts out of their name, or if they have a really big asset protection concern, then that's when we start to look into that. So it just depends, but that's why it's so important to talk to a qualified trust and estates attorney, also from a tax perspective, because if an asset's in a revocable trust or individual name or an enhanced life estate deed, there's what's known as a basis step up. So if I pass away, let's say I purchased a home for $100,000, and now when I'm about to pass away, it's worth $1 million. If I own that property or that property is in a revocable trust on the date that I pass away, the Internal Revenue Code says my beneficiaries get a step up in basis from a federal income tax perspective. So if they turn around and sell it the next day, their new basis is the fair market value on the date of my death, $1 million. They sell it the next day, they don't pay any capital gains
Oh, that's
tax.
amazing.
And that's
Oh
huge.
my God. That's
Huge. If it's
changer.
a real estate portfolio,
And you bought
especially
it
that
at
has
20, 30 years ago at a low price, inflation, everything. It's worth $1 million. You bought for 300. There would be a 700. That is amazing, because that changes the game totally for the people that are inheriting it. Because then you're like, no 1031 needed. We're good. We're solid. That's awesome.
Yeah.
I also know that you could put your brokerage account into a trust, and the trust could run your brokerage account, which means that that asset that you have in your brokerage account would be passed out. If you have everybody in the trust anyways, your kids and your wife and all that, if you pass away, the brokerage account is ran by the trust, basically by the trustee, the next designated trustee, which then can pay out or do whatever it needs to do.
Exactly.
And I think that was one of the big aha moments for me. It was like, holy cow. So I have my brokerage account in the trust. That means that brokerage account, if I trust the right people to run that brokerage account for me, my stockbroker and whoever he recommends for the next person, et cetera, that could keep on growing. Like the richest man in Babylon kind of idea.
Yep.
Like you could live, that trust can live for 1,000 years, basically, and keep growing and growing and become that entity by itself that keeps your family going for generations and generations.
Yeah. And the same thing, just like with real estate, that basis step up benefit from the tax code, same thing with stock. So if mom and dad bought IBM, Apple, whatever it is, same thing, you get a basis step up. So if you sell it the next day, you don't have to pay any capital gains tax.
Holy cow. That too. Amazing.
Major.
How amazing is that? And that could pay out throughout the lifetime of the people that are inheriting it. So
100%. But a lot of people just don't know that is usually, they don't know. So maybe, let's say, even if there's a probate, you still get the basis step up. But let's say you didn't know to tell Vanguard, or you didn't know to tell whoever, hey, make sure you step up this basis.
Yeah.
Maybe you have a good financial advisor, so they make sure it happens. But if you don't know to check that, they may forget to do it. And how would anyone ever know that information?
Exactly.
If you're not a tax attorney, a CPA, a savvy real estate professional, how would someone know that?
Yeah. And the other thing is that I was just thinking about this little side thing, but you know how they have the funds or like investment accounts for children? Oh, start doing it at early age. So when they become college age, they can pay for the college with it. Now, guess what? If you have a trust and you do it in the trust and they're in the trust, guess what the trust can do? The same thing as that account, but you get a way better return, more than likely, in the trust than you would on that. I don't even know how they call them, the student funds exactly, but you probably get a 20, 30% return on your trust year over year. And you don't have to open a kid's account, because you can have, the more the money, the bigger it can grow. So you're putting those $10, $20, $30 in the kid's account. It's growing tiny bits. Now, if you have a trust and it has a brokerage account with $500,000 on it, that's growing totally different pace. That's growing at a totally different pace. And you could do the irrevocable trust, as you said, saying that when he turns 18, if he chooses this or this profession, the irrevocable trust will pay out X amount for his education or her education.
Yeah. And what's nice is, like, I have a revocable trust. Very straightforward, very simple. But when I pass away, it automatically becomes irrevocable, and it automatically creates all the trusts that I need. So it's not like you have to go and create all these different trusts and these different things, and it's very confusing. It's all really not that hard, and you should do it through a qualified attorney. But at the end of the day, it's not that complicated, but it's so effective. And then as far as paying kids Sometimes it makes sense to still have accounts for children, especially if you're employing them in your business and then you're able to either reduce your taxable income or you're able to create Roth IRAs for them or whatever it might be, then it might make sense. So it's like the most lawyer answer ever. It depends, but that's why you need a team around you. You need a good trust and estates lawyer. You need a good CPA. You need a good financial advisor. You need your real estate professionals because all of those people together are your money team. And you don't have to be super fancy to have that team around you. And doing quarterly or twice a year money dates with you and your spouse or your partner to make sure that team is all aware of what's happening. That, if you do that year after year, you will build wealth. Guarantee it, because there's no way that with compounding and interest and just like your brain expanding and having a supportive team that you won't become wealthy.
And of course, teams can get much further with the team. Like you don't have to do
Yeah.
everything on your own. You don't have to know everything on
Yeah.
your own. That's why
Yeah.
that's why you have professionals. So let's get to the next question. Probate disputes can rip families apart. In your experience, what emotional triggers fuel most inheritance battles?
The biggest thing I would say is at the end of the day, we're all humans with very messy emotions. So if someone feels slighted or like mom or dad didn't like them as much or that they didn't know and it was a surprise of what they were to receive, maybe they received less or maybe they received the brother or sister received the business and they received something else and they feel like it's not fair because the business is going to generate all this money and what they received isn't. I think it's just sometimes the lack of talking about it before the person passes away because you're already grieving and now you're feeling like, oh, mom and dad didn't like me as much or they didn't name me as personal representative or trustee, so I'm the less favored child. And that's often when I see probate litigations begin. There's maybe some family drama that gets amplified by grief, gets amplified by money and feeling maybe mistreated. It's not always a perfect solution, but in many of the families that we work with, we say, let's sit down before you're sick, before you pass away, while you're there to explain to the family, this is what I'm doing. This is why I'm doing it. Hearing it directly from the client and the mom, the dad, whoever it might be, is so important. Also, if there's a blended family, so if there's a new spouse, if there's children from a prior relationship, that's another trigger point that we see all the time, especially if there was not a good estate plan in place. So you asked me for a story out. I just thought of a good one. So it's not good. It's awful. It's really sad, but we use this example all the time, especially when we have blended families. So we had a guy call us. He said, hey, my dad remarried. So I have a stepmom and my dad only had a will. My stepmom only had what we call I love you wills. So everything to spouse, then to children. So he said, okay, so dad just passed away over the weekend. Everything has now transferred to mom, not in a trust, just outright stepmom, not in a trust, just in her individual name. And now she's changing her will. She's removing me as a beneficiary from her will. She's putting in her nephew. What can I do? It was the dad's assets. It was his house in Boca Raton, $2 million house. It was a brokerage account. It was bank accounts. It was life insurance. What can I do now that stepmom has everything in her name and is writing me out? That's not what my dad wanted. And we unfortunately had to tell him there's literally nothing you can do unless she has an incapacity issue or you feel like something really weird is happening here. She is now the rightful owner of those assets. And even if it is entirely contrary to what your dad's intent was, she can do whatever she wants. And now, $5 million, you are going to completely lose out on your inheritance because the attorney that drafted those wills probably didn't say, hey, this is a stepmother. Maybe do we want the assets to go into a trust for her benefit, let her have access to those funds during her life, and then have it go to the son locked in as the beneficiary? Or maybe do we want some of the assets to go to son now at dad's passing? I highly doubt that conversation was ever had. And unfortunately, that's a $5 million inheritance that now the son never got to see.
That is really sad.
Really
That
sad.
is
And it
really
was
sad.
hard to deliver like that answer of there's nothing you can do. That sucked.
I hope the son's really standing on his feet and can show them, because the best revenge is to show them success. Stand on his own
Yeah,
feet and make that money. I hope he can do that
I
in
know.
that
I
case, because
know.
otherwise, that's what happens. Have you seen cases where real estate, maybe a vacation home or investment property, was the breaking point in a family unit?
Yes. So what we often see specifically with a family home or a vacation, it's usually even a vacation home because there's usually so much emotion tied to the home in Nantucket or the home in Amelia Island, like wherever it might be. If everyone is just getting that asset in their individual names, let's say it's three siblings, they're all just receiving it. So now they're co-owners of this property. And now they have to decide, do they want to sell it? Do they want to keep it? Do they want to rent it out? Oftentimes, one child is very successful financially. So they're like, of course, let's keep it. No problem. Maybe one child is a teacher and they're like, how am I supposed to pay for this? If I owe one third of the expenses, I can't afford that. And then the other is, I just want my cash. I want my cash money right now. Let's sell this bad boy. And they can't agree. This is the tale as old as time. It happens literally every day. And it is a big problem that often leads to litigation, even if everyone got along, just because they have different lifestyles, they have different goals. So if we have real estate, home, vacation home, even an investment portfolio, we talk to the family, we say, okay, do you want everyone to just receive this in their name? Maybe we put in the trust that the home must be sold. It must be sold and proceeds split equally. So this never becomes an issue. Or maybe one child gets the vacation home because they're some big finance person in New York, and then the other kids get equalizing distributions of other assets that they don't have to maintain because they can't afford to. Just taking the time to ask your clients these questions, walk through the various scenarios with them is life changing because it's not that there's a right or wrong answer in general. It's what makes the most sense for that family. And who knows, your children more than the parents.
Yeah, that's always the case. You always have usually you have the guy that makes good money, you have the guy that is in public service sometimes, and yeah, it's always such a mixture that you raise the children, same person raised them, but they become so different. You
Yeah.
and I were just
Yeah.
seeing that with our young kids, and I have a mellow son and a super active, like energy bomb leader kind of daughter, and I'm like, wow, it's so different personalities.
Yeah. It's wild.
Yeah, it is.
It's
It is.
wild.
It is. And might become a geologist, and the other one could lead a big company and become a big CEO. You're like, holy cow, two really
I know.
different spectrums. But I hope they'll
And
always
from
stick
such a young
together.
age.
Yeah, exactly. One will help the other if needed, and back and forth, because that could be something as a solution.
Oh
Um,
yeah.
what
Yeah,
what
absolutely.
what preventative strategies do you recommend for keeping peace when emotions and money collide?
So really just making sure one that you talk to someone who can help you get a plan in place that works and ask someone if you're interviewing trust and estates lawyers like what actually do we go into in the meetings? How much time do I have with you? Do you bill on a flat rate? Do you bill hourly so you get a sense? Because a qualified trust and estates attorney will sit down with you and make sure that the plan encompasses what your goals are. Also, your goals might change. You and I both have very young children. We're still figuring out who they're going to be. So making sure that you're revisiting everything at least every 5 years, but I would say every single year, revisit what your estate plan says with your attorney and just say, hey, does this still make sense as children grow up, as life changes, as our wealth grows? Does this still make the most sense? Maybe I might want to add a corporate trustee in now. So it's a third party trust company that's going to handle it, a professional. I would say is the biggest things. And just making sure that whoever you work with is looking at each asset from a tax perspective, from a legacy perspective, from a probate avoidance perspective. I think all of that is just so huge. And just be honest with your family dynamic. We all have skeletons in the closet. We all have people that were like, oh man, I don't know what that family member is doing. Be open and honest with yourself and your professional team around you about that so you can try to mitigate those issues because no one wants to see families torn apart. No one wants to see their hard earned legacy fought over by children or loved ones. Like I said, if you have blended family, definitely take that into account. If you're getting married, so many of us are getting married later in life where we already have assets. Make sure you have a prenuptial agreement in place. If you already got married, maybe do a postnuptial agreement in place. So there's clarity on what happens. While you still love each other, you talk about what would happen if something unfortunate happened to your marriage. All of those things I believe are just part of being a financially healthy and responsible person. And I believe that when you're financially healthy, your stress levels go down, your family gets closer, it inspires everyone to be more creative and more entrepreneurial and more financially savvy. So as you can see, I get jazzed up about it because I really do believe like estate planning is not just like something dry and dusty and boring. It's actually a part of your financial health. And if you focus on your financial health, like I said earlier, you will build wealth. I didn't mean for that to rhyme, but you know what I'm saying.
That is awesome. You mentioned corporate trustee a couple times already. I didn't have a question for this, but it sounds really interesting. So I want to open up the can of worms here. What is a corporate trustee and how do they operate? And how can you trust them? Like, you don't know these people. Tell me a little bit about it. What is that? Like, they run your trust
Yeah.
basically for you after you die? Okay.
Yeah. So it's something
It's like
that
a
we
law firm
introduce.
or
Some law firms do serve in that role, but we usually don't. We like, if there's a corporate trustee named, we want it to be a professional trust company. So my law partner actually used to be a corporate trustee. So she was with one of the big US Trust, Bank of America. She was someone who, if someone named Bank of America US Trust in their will as personal representative or in their trust as trustee, she was administering the trust. So rather than your cousin or your uncle or one of the siblings running the trust, a professional is doing it. They're making sure that the tax returns are filed. They're making sure that the assets are all gathered up and everything is accounted for, that accountings get out to the beneficiaries. So it is a way to make sure that everything is done properly. And it's also a way to avoid those family conflicts or avoid maybe someone just distributing their entire trust to themselves if they're named as their own trustee. So it can make sense for really wealthy clients. And then it can also make sense for clients. We have one situation right now where we have a blended family with a large real estate portfolio. I think there's 3 children on one side and one joint child on the other. And they're like, look, they won't agree. We already see the drama happening. They get along, but we see the others bully this one child, or they feel like they're different. They don't feel as special because they're not a joint child. So there's this tension behind the scenes. So we're working with that client, even though they're not worth 40, $50 million. I think they're worth probably like 4 million and growing, to make sure that if something happens to both of them, God forbid, there's a professional that will take custody of those assets and make sure everything works. Now, you asked, how do we know if you can trust them? We usually only work with really qualified, that have trust companies that have enough assets under management. And the trust also provides for, if they do a bad job or if that business closes, the ability to replace that trustee as well, because there are fiduciaries. So they're held to a high standard of administering the trust for the benefit of the beneficiaries. That's any trustee, an individual trustee or a company.
how does that operate if you don't have anything like concrete written down in your trust? Would they be, let's say the siblings go up to them and like, hey, I need a $10,000 today just because. Would they be the ones signing off on it? Of course, because they're the trustees, so they have to sign off on it. Would they logically look at it and say, I deny it or I take it, I could do it? Or would that be like an even distribution? How does that work? Because they're not
Yeah.
family, so you don't really. It's like I'll go, Mom, I need a new car. Can you give me $50,000? It's not the same thing. Then, hey, this is a corporate trustee, so they're like, how do they make those decisions? Do you know?
Yeah. Oh, yeah. So, first and foremost, they're going to review the terms of the trust document and try to ascertain the intention of the grantor, the person who created the trust. Or the grantor might be living if it's an irrevocable trust, so they can always get further information. But the trust should provide for when the grantor felt it was appropriate to make a distribution. So, often trusts just say, you can make a distribution for health, education, maintenance, and support, which is a very broad standard.
It's really vague.
Or sometimes, yeah, it's very vague, and it intentionally. Or it might say you can also make distributions for the purchase of a business, for a wedding, etc. So the trustee is going to first look at the terms of the trust to see if that request aligns with the terms of the trust. They're also going to look at the assets as a whole. So if it's a $5 million trust and the beneficiaries, hey, can I get $10,000? They're going to ask what the purpose is for. But as long as they feel like it's not anything, it's not drugs, and I'm sure no beneficiary would be like, hey, it's for drugs. But you know what I'm saying? They're
Yeah.
going to try to
I'm going to
ascertain that
Vegas
it's.
tomorrow. Can I have 10 grand?
And if the trust allows for, like we have one client right now, I want my kids to be able to travel. Maybe the corporate trustee would say, okay, your mom said travel was fine, so here's your 10K for Vegas. But if the trust is only worth $100,000 or $500,000, it's gonna make it a little bit more, I don't say difficult, but there's gonna be more scrutiny. Does this make sense? Because the trustee's job is to try to, if the grantor wanted
Bro,
this, to make the trust last for as long as possible. So it depends on the intent of the grantor, which again is why you want to have a good attorney who's going to ask you what your intent is. That's a really good question, though. So it depends on the trust company and the terms of the trust.
I thought this was really cool because I haven't heard that term. I knew you could nominate your attorney or anybody you want to be a trustee, but that they have actually people that do this professionally, it opens up a totally different world because now you're like,
Yeah.
okay, let me date these people for a little bit before I pass away, see if I like
Yep.
them, see if I who's going
Yep.
to be the guy in charge, have a lot of conversations with that person, bring him out to play golf or whatever, make sure they know what your intent is with the trust, and then okay, I'll nominate you. You know what my vibe is and what I'm thinking of. So I would trust you doing this for me and
Yeah.
maybe extend that trust and growing the trust even during its life, doing the right investments, et cetera, et cetera. That would be your basically your right hand man. Your CEO would be that person that's carrying on the legacy. So it's a
And
big
some
decision, and
It's a
some
big decision. And some trust companies will also manage the assets for you. Or some trust companies, if you have your preferred financial advisor, they'll just say, we'll be the trustee. You'll have your financial advisor. So these are all the things that there's no one right answer. It's making sure that your professionals around you are guiding you in the right direction. And if, let's say, there's a special needs beneficiary, that's even more important that you have a qualified, if maybe you name a couple of family members, but if they're all gone, we have these conversations all the time with clients with children who are special needs. Maybe they're on an autism spectrum or they have Down syndrome or whatever it might be. And they're like, look, if we're gone, it's a big problem. If everyone else is gone, it's a disaster. So having a trust company in place that can help administer that
oh,
trust
for
is so
sure.
important.
Oh my
So
God, that's
important.
like a totally different ball game then. Yeah,
Yeah.
I could see that being a really good thing for people with those needs. Yeah, definitely.
Yeah.
So
Yeah.
real estate is often the centerpiece of family wealth. How do property titles, investment properties, or blended families complicate estate planning?
So it depends on the circumstances, of course, if like I keep saying that, but if it's maybe too complicated or if it's not the right tax structure, it could result in tax inefficiencies. It could result in maybe the decedent's or the grantor or the client's intention just not being followed the right way. I've seen sometimes back in the day that I told you guys the exemption is now $14 million per person. It used to be much lower, like
Five or something like
500,000.
that?
And yeah, five, it was 5 million before that. It was 1 million before that. So I see sometimes very complicated trust documents that are just not necessary anymore, or we just need to revisit them. So it's really just, again, I feel like a little bit of a broken record, but it's true. Making sure that your plan aligns with your facts and circumstances and assets is worth its weight in gold, truly.
Yeah. Can you share a real life case where a creative legal solution helped avoid a major family dispute over property?
Let's see. I've definitely dealt with a few really wealthy families over the years,
The
especially in Latin
Rockefellers,
America.
the Rothschilds, just kidding.
There's a couple of families that I'm thinking of in particular that were very wealthy families in Latin America, and they had assets all over the world, assets in Latin America, Europe, Asia, the US. And so making sure that the estate plan was covered from a, because they were US at the end of the day, US perspective, and making sure it's tax efficient and everything is structured in a right way that aligns with each of those countries and those jurisdictions was really huge. But from a US perspective, because they had done their planning properly, they had moved everything out of their estate before they even became US. Their family ended up saving over $100 million in estate tax because of the
Wow.
planning that we had done, which some people might say that's good or bad. I don't know. But at the end of the day, there's no requirement that we must pay the most amount of taxes, income tax, estate tax. We
No,
all
I think
have
you
the
should
ability to,
pay what the tax
yeah,
code says. And
yeah,
if you could save, come on, that's not the tax code is there. If you're really
exactly.
savvy, you get to save money. And I like Robert Kiyosaki. I'm a big investor fan, Tony Robbins, Robert Kiyosaki, all the big guys out there. And they always say we don't pay taxes because the tax code offers it to us. It
Yeah,
doesn't matter who you are. If you're following the tax code, you get to live like it. So,
yeah.
and you just mentioned international properties. I myself have international properties, and that's always a big question. Like, how do I stick that into my estates or estate planning or whatever document we have? Because Europe is one place, and I'm planning on getting properties probably in multiple foreign countries because I'm planning on retiring in the Mediterranean. So that might be a thing for
I
me
love
too.
it.
So
Yeah.
just how do you plan for that and how do you put those in? And is the American standard the number one standard, or do you have to do a local trust in that country as well? Or do you have to coordinate with an attorney in those countries? Or how does that work? Because now you open up a new
Yeah.
can of worms in my head and I just can't stop thinking about it.
That's what I do. That's what I do best. So you're going to want to have both your Florida attorney and the attorney co-counsel in that jurisdiction to make sure that everything works, because many countries you're able to move real estate into a Florida or a US trust, but in other jurisdictions that may not work and may create issues, tax issues, probate issues in that jurisdiction. So you want to make sure that you have your main Florida estate plan and that it really encompasses everything, but also that you are talking to attorney. Your attorney is talking to attorneys there to make sure that everything works from a US perspective and doesn't cause any issues in those countries as well.
In your case, would you find those attorneys to help out?
Yeah.
Okay. So you guys are
Yeah.
all white glove service there.
Yeah. We're like matchmakers. We really are. We
Yeah,
put the
yeah.
team together, and obviously the client's always going to vet them to make sure that it's the right team, but we'll make the introductions, we'll put it together, and then we'll see.
That's cool. That's cool. That gives me a little ease of mind that we could work it out in the US.
Oh yeah. Oh yeah, definitely.
What this is another question because I had a big sale a few years back, $3.2 million here in Ormond Beach. It was a top sale for a year, I think, in our area, which is not big for you in Miami, but for us, it was
That's
like, whoa,
awesome.
it was in the newspaper for God's sakes. And
Congratulations.
the owners of that home, thank you very much. The owners of that home have, how did they rescind their US citizenship? And they were Italian, so there was FERPTA involved, which caused legal issues, which actually turned out to the benefit of my buyers because we could renegotiate the whole deal, and we were agreed at 3.6, but at the end we got for 3.2, and they had to pay their FERPTA because they were trying to pull some tricky. And our attorneys were amazing. At the end of the day, I introduced them to a good company, and the question is here: what if, because America is one of the only countries that have dual taxation. Basically, if you're a resident of any other country, you still have to pay taxes in the U.S. no matter what. So that comes to the point here is, hey, if I retire in the Mediterranean, let's say, and I don't want to pay tax in the U.S. anymore, and I say I'm going to give up my U.S. citizenship for the rest of my life, whatever, I can still come back on a visa or whatnot, but I don't want to be a U.S. citizen. I don't want to pay taxes there. Would my trust still work? Or do I have to be a U.S. citizen for my American trust to work?
So there's so many things that could be like a whole podcast in and of itself, but just a few things to think about. One is the US has what's known as an exit tax. So if you're giving up your US citizenship, you may end up having to pay a big fee to the United States in order to do. So it's not that easy. It used to be that easy, but the IRS is like, no, we're not going to allow that. So it's not that simple or always free to give up and renounce your US citizenship. But let's say you did that. We've had clients who have done that and we've gone through the process with them and they've paid their fee. Usually you may not want a Florida trust from a tax perspective, but that's a whole other thing. You might have a Florida trust that's actually treated as another country's trust for a tax perspective. It depends again on, that's really getting into some like fun stuff. But again, it depends where you're moving to. It depends on the circumstances and your goals and the assets that you're holding in the US.
It's not like I would give up my U.S. citizenship because it's one of the most valuable citizenships to have, but it was just a thought because I thought about these clients and I'm like, they gave it up for some reason. They were Italian, so they moved to Italy, back to Italy. And I was like, that's an interesting thing. They got their citizenship, they made money, and then they gave it up and went home.
Yeah.
Kind of deal.
Yeah. But who knows if maybe they didn't do that leaving procedure properly and now they won't be able to come back in even on a visa. So
yeah, you never know. That's scary too. Because your kids are going to be here probably because they grew up here. This is their house or their home.
Yeah, that's a problem. That's not worth saving some money.
So
if that happens.
Exactly. For realtors listening, what should we be aware of to guide clients towards better estate planning while we're helping them buy or sell?
So if they have children, I would definitely say, hey, have you thought about a trust? Have you thought about trust planning? Have you considered the right way to title this property? If they're purchasing it with a business partner, is this going into an LLC? How are you going to structure that, or some other entity? How are you going to structure that in the best way? Obviously, if it's your homestead property, you don't want to put in an LLC because that will cause you to lose homestead. So many different factors, but I would say ownership and titling and then estate planning are the pillars of what you should do. If someone's non-US and they're buying US situs real estate, they probably shouldn't be buying it in their individual name. They should probably be buying it through a structure. So again, just knowing the things to hear out for and then say, I know a person, I know a good trust and estates lawyer, or I know a good real estate lawyer. Let's just have a call with them and see what they think. Because I've seen so many things where the purchase has occurred. Now you have to undo it. It's much more complicated if you had just taken title in the correct way from the get-go.
That's awesome. Yeah, that makes a lot of sense. What are the biggest myths about wills and trust you hear from clients?
I think the biggest myths I would say are I'm not old enough, I'm not wealthy enough, or if I do this, I'm going to die immediately, which is wild to think about. I haven't had any clients who have just immediately passed away after signing their estate plan. But the reality is, if anyone is 18 or over, even if they have no assets, they should have something in place. They should have a power of attorney. They should have healthcare documents to say who can make decisions for them for financial and healthcare purposes. If they're unable to do, say your child goes away to college and they get in an accident, they are now an adult, they're 18 or over. HIPAA will not allow the doctor, the hospital to provide the parents with information. They might break that rule, but they might not. You may have to get on an airplane to go to your child and have no idea if they're okay or not. Very scary. So anyone who's 18 or over needs something. And then as you start to accumulate, build your family, you need to upgrade. Maybe you start with a will. Maybe then eventually once you have kids, you get a trust. It can grow with you, but I think so many people think it's something that's not necessarily relevant to them. It's something their grandma needs to do when, again, it's just part of your financial health. And by getting a plan in place, you're being savvier than the vast majority of Americans. I think it's 30% of Americans have an estate plan, they say, but based on what I see every day, it's probably more like 5% have an effective estate plan. And that's the reality of it. The lucky 5% or whatever it is that actually has a good estate plan is going to have everything be effective and efficient, avoiding litigation, avoiding tax issues, avoiding probate, whereas the rest of America is going to be paying the price of not doing the planning in the right way. And that's just what I'm trying to change, but that's just the reality as we have it right now.
How do you convince families that estate planning isn't just for the wealthy?
I think once we start giving examples and I share what I've done with my own family, which is a revocable trust for my spouse and for myself, and we start giving the examples of if an asset stays in trust for children, it's basically you're giving them a prenuptial agreement, you're giving them creditor protection, you're keeping those assets out of their estate tax base. So even if they have 15 million, anything that you give them never enters into that calculation. When we start explaining it from a way that really hits on families' goals, I'm very proud. We tend to have a very high conversion rate because I think we explain it in a way, at least I hope we explain it in a way that is very simple to understand, that makes sense for the client, and that they feel good about and they feel safe and comfortable to take the step in getting their plan in place.
And then the last question is, if you could give one piece of advice to families right now about protecting their legacies, what would it be?
Just if you don't have any estate plan in place, just schedule a few consultations with a couple different attorneys. It's dating. See who you like, see who you feel comfortable with, see what fees make sense. An average good trust plan is going to run you about $4,000 to $6,000. It could be a little bit less, it could be a little bit more. If it's a lot less, run as fast as you can because it's not going to be well done. I can guarantee you that. The amount of time that we spend with each of our clients, if we only build like $1,000, there's no way we could do that. And just see who you're comfortable with and take action, inform yourself, and you will be light years ahead of everyone else around you. And then usually then you'll start telling your friends, hey, I did this might make sense for you, but just take action. Sometimes we get overwhelmed, we get analysis paralysis. Just take action and make sure that you at least have an understanding of what you need to do. Even if you don't act on it immediately, you should, but just get an understanding of what it is that you need to do for your family. That's my best advice.
Thank you, Lauren. Thank you. Thank you. Thank you for pulling back the curtain on a topic that affects every family, whether they realize it yet or not, from hidden debts to probate fights, from property disputes to protecting legacies. This episode has been packed with insights that every homeowner, investor, and realtor should take to heart. For those who want to connect with Lauren, you can find her at Lauren Alexis Klein's website, on Instagram at Lauren /_Alexis /Klein, and on YouTube at Lauren Alexis Klein. You will have these handles in the show notes underneath the video. And if you enjoyed today's episode, don't forget to hit that subscribe button on YouTube, Spotify, or Apple Podcasts. Leave us a review and share this with someone who needs to hear it. I'm Lancelot Lenard, your host of the Real Estate Roundtable, where we bring you the people, the stories, and the strategies shaping real estate today. Until next time, protect your legacy and keep making moves. Thank you, everybody. Thank you for joining us on Sir Lancelot's Real Estate Roundtable, where we've unveiled the mysteries of real estate together. Remember, in this kingdom of possibilities, every dream home is just a discussion away. I can help your real estate dreams come true. Just call me at 786-449-7518. Until our next roundtable, may your ventures be prosperous and your homes be filled with love and joy. Farewell, fellow knights of real estate.